small claims court for stealing my videotapes. And Brenda tried to make it my responsibility that she didn't get a call until after 5 o'clock to put the tapes out at Yorktown. Why do we have to call her and tell her to put out the tapes? Why? After the tapes are cable cast, take them downstairs and put them in the bookcase. Why do they have to be told? There's no legal basis for that. This Curvis is as crooked as Charles Dolan is. All the time I was in there, that's a pretty good idea. Now we go to the Bronx. So-called sawmill river. That's it. That's all there is to it. That's all there is to it, folks. Present their evidence to a special grand jury pursuant to the provision of 18 U.S. Code 3332. That this court convene a grand jury to investigate the crimes complained of herein, pursuant to Federal Rules of Criminal Procedure, 6A. That this court issue a declaratory judgment, pursuant 28 U.S. Code, Section 2201 and 2202, that appellate panels must address the issues raised.
Must involve
that the deliberate failure of an appellate panel to address issues raised
color of state law
continues
caused you intentional infliction of emotional distress, and it did not inflict a liberty or property interest, forget it. You don't have a claim. Just as an example, now sometimes this stuff really is deadly. We had a guy up in Minnesota. Police had a search warrant, or rather they were sheriff's deputies. They came in, they had a search warrant for his truck, but they didn't search the truck. They drove off with it and kept it for 3 years. This thing was like a $2,500 truck. They just settled this last month for $10,000 because they violated his due process of law rights under the 14th Amendment. In other words, be very, very sure that you have a federal constitutional or statutory right violated by someone acting under color of state law that dealt with a liberty or property interest. And the last thing you've got to understand about a Title 42 is if you think a state agency did that, and if you sue them and the money's going to come out of the state treasury, that isn't going to fly either, because any time that money has to be paid out of a state treasury, unless the state has waived its immunity under the 11th Amendment, they are protected by the 11th Amendment, and it will go absolutely nowhere. So be very, very careful when you set one of these things up that you understand that you're in the right court with the right cause of action. And sometimes what you'll find is the very thing you can't make fly in a federal court, you can get it off the ground with little or no effort in a state court, and vice versa. California, for example, has a rule that exempts state actors from liability for the constitutional deprivations they cause, but that allows you to park it in federal court and makes it even easier, because there's a lot of case law or published opinions that tell you that a case in which the state has no remedy, well, you park it in the federal courts, it's no problem. What we're going to do now after lunch, we're going to break here in a couple of minutes. In fact, actually, Peter's got the 1-minute sign. What I'm going to do is I'm going to show you all the different federal jurisdictional goodies that you can use, because some of these things are literally a ticket to stealing from people. I mean, I'm going to teach you how to steal from the government just the way lawyers steal from everyone else. And you like that idea, huh? Okay. There's more of this going on than you can imagine, and the thing is that it's so much easier for lawyers to get their money up front. You have to earn this. In other words, you can get it started, but you may not collect for a year or 3. Yeah, go ahead and close it up, and then what time you got now, Peter?
Well, I'm not sure. We'll do that right now.
Okay. Make sure everybody's back on deck in 2 hours.
First of all, we want to remind you that if you want to see how it's supposed to work and how the Constitution was designed to work, this is the Jones edition of Blackstone's commentaries. It's in the Irwin Rommel catalog if you want to play by mail. Ambassador Fox. Info pack. We have discussed Dwayne Rogers' program, Who Do You Trust? And we have a flyer on it that is not in your info pack. And if you would like that flyer, it'll be up here on the table. Just take one sheet, please. If we run out, we'll run down to Office Max and do some more of those. We are the Erwin Rommel School of Law, care of 4842 North Magnolia in Chicago. 60640-4710 is the Babylonian Ghetto number. We're connected to you telephonically, 773-878-0681. Dedicated fax is 0682. We are going to take 90 minutes for lunch, and we'll be right back. Thank you. Welcome back from lunch. A quick 60 seconds with you before Michael returns to the podium. Erwin Rommel is not a monolith. You will get varying opinions on varying topics relating to, the flag issue, citizenship status, jurisdictional arguments from Dwayne and I, and from Michael. The reason Michael presents these seminars is, as Dwayne and I will both tell you quite candidly, if it came to a serious civil or criminal problem in our family, the entire case would be turned over to Mr. Brown. And whatever Mr. Brown said to do would be done as expeditiously as is possible. The reason we insist on a professional audio tape rig at our seminars is so that you can review what you learn here over and over again. Even if you disagree with Michael or Dwayne and I on any particular issue, our goal is to train you to successfully litigate that issue, whether you agree with us or not. And without any further delay, Michael H. Brown.
All right, what we're going to cover this time, we're going to continue on jurisdiction, but before we do, I want to remind you of something. I've said before that the law is a weapon. Now let me prove it to you. If you read von Clausewitz's classic on war, he wrote it in 1812, he pointed out that a function of an army is to disarm its enemy. Now, has anybody noticed, I can remember when I was a kid, that Golden State Arms would sell you anti-tank weapons, they would sell you machine guns, they would sell you pack howitzers. Have you noticed that those weapons are no longer available? That we have been disarmed? Now, how did they do that? They did it through the legal system. First, Congress enacted the laws, and then the courts enforced them. The law is a weapon. Now, Edmund Burke tried to explain this to the British Parliament in 1775, and what he pointed out was, he said, look, he said, the reason we're not getting away with anything in the colonies is, he said, because everybody there is a lawyer or a smatterer in law. In other words, the colonial militias weren't just out there with, trying to do battle with handgun control ink. They were smatterers in law, and what Edmund Burke pointed out, and you'll find part of his speech in Son of Erwin Rommel, what he pointed out was that in Europe, when you got ready to clobber people with the legal system, they couldn't see it coming, and they didn't know what happened to them until after they had already been enslaved, whereas the colonials, you pulled a stunt with them, I mean, you even suggested it, and they already knew what was wrong with it as far as the legal principles go, what the historical precedent had taught them, and they were cocked and primed before the British government could even implement it. And unless you understand that today a knowledge of law is just as important in 1997 as a knowledge of flintlock rifles was on the frontier in 1797, you are basically wandering around this society unarmed. Now, what I'm going to do next is I'm going to start going through the jurisdictional statutes. Remember, caption, statement of the case, jurisdiction, parties. Well, we're on jurisdiction, and I'm going to introduce you to some of the goodies that are available from the federal government. Oh, and let me, one aside here, when I hit you with Rule 38A and then I showed you in 38D where the whole thing is a farce if you don't squeak up, well, let me warn you, you better check your state rules of civil procedure because, for example, in the state of Arizona, they've got 38A, B, C, and D just the way the feds have got it, that if you don't ask for it, you don't get it. And in the state of Colorado, it's even worse because they don't even have a constitutional provision for a jury trial in civil cases. It's only by act of the legislature, and in Colorado, they called it, you guessed it, 38A. You'll double check that any time that you're going to sue somebody in a court. Don't even think about having a bench trial because judges are unpredictable. It's like I pointed out, half of them have substance abuse problems, and your odds are about 1 out of 10 of getting a Rudy Brewster. In other words, somebody who's just a complete idiot. Now, under the jurisdictional sections, what I'm going to do is I'm going to go down. Remember Title 28 United States Code? That is where you find most of your jurisdictional statutes. There are some others. I'm going to show you one in Title 18. Anybody recognize this one? Nobody recognizes it. Okay, well, I'll hit you with this one. Title 31, and then after that we're going to get into the Federal Rules of Civil Procedure. Now, what I'm going to try to do here is I'm going to go through some of this, and then I'm going to ask those of you who have questions before we get into civil procedure. Stand up the chow line here at the microphone and let's get this taken care of because I got to hand it to you. This is the largest room I've ever had in which absolutely nobody broke the rules during the intermission. Remember, no questions during intermission because that way it deprives the other people in the room of the answer. Now, I'm going to go through this by the numbers for you. If you have any questions, by the time I get through this jurisdictional stuff, anything that pertains to what we have covered already or anything close to it, there's the microphone. You'll get to be a star. Your image will be preserved forever on celluloid. And the other people in this room will have the advantage of the question that you asked and possibly the answer that I give in response. Now, whenever you do a Title 42, this is the other statute that you wire in with it. Title 28, Section 1343, because this is the one that allows you to collect money damages. You can do a Title 42 and walk away without a penny. It's Title 28, United States Code, Section 1343. Some people in the back of the room complained that they couldn't, they couldn't see this. Well, that's okay because even though they can't see it, I'm going to say it loud and clear, and then you're going to have it on the audio tapes. And you can listen to it over and over until you wake up at 2 o'clock in the morning and think, oh man, I don't want to hear Title 28, Section 1343 ever again in my life. Now, Title 28, Section 1332. What this is called is the Diversity Jurisdiction Statute. And what this statute allows you to do is if you are a resident of Pennsylvania and you want to sue somebody in North Carolina, and you know you have to do it in a court that sits in North Carolina and you're afraid of running into the good old boy network, if there are no plaintiffs on one side or defendants on the other side who are inhabitants of the same state, you invoke this statute provided, however, that the amount in controversy is over $75,000. So you only have two qualifiers here to take this statute and take a state case and park it in federal court for any type of state action. All right? In other words, it takes you completely out of the good old boy network and allows you to park it right in a federal court, provided those conditions are met. Now, if you have a plaintiff who lives in Pennsylvania and a defendant who lives in Pennsylvania, forget it. Federal jurisdiction will not attach. Now, keep this in mind because you may decide you don't want to put this clunker in federal court. So you have got to name somebody in the same state to keep it out of the federal court. Title 28, United States Code, Section 1391. This is called a venue statute. And for the most part, it basically tells you that you have to park this federal lawsuit in a court in which the defendant resides, the cause of action arose, or a piece of property that you're squabbling over is located. Now, there's one kind of nifty exception here. It has to do with the executive department. This one here, if you decide to sue Janet Reno or any other member of the executive department, allows you to park it in the federal court where you live. In other words, they have to come to you. I believe that's paragraph E, you'll check. 1441, now you're going to see a lot of this. If you follow what's going on in a local courthouse, Title 28, United States Code, Section 1441. That's the removal statute. What that does is if you sue someone or they sue you in a state court, and one of you, and it's always the defendant, let's say you got sued in a state court by somebody who lives in another state, and you look at this thing and think, oh man, I know these guys in this local court, I don't want to deal with this, and the amount of controversy is over $100,000, or there's some other reason for federal jurisdiction to attach, this is the removal statute. This allows you, by filing a simple motion, and in most federal courts, you just pick up a telephone and they send you the forms, to take a state course or a state case immediately out of the state court and park it in a federal court. And I'll tell you what's funny about this is Peter Simpson had a case in which he's been going round and round with this state judge, this drunken maniac by the name of Thomas K. McGuire. And McGuire finally got too far out of line. They didn't mind him so much being a drunk and getting out of drunken driving tickets and all that. But when he started using a neighbor's house for target practice with a pistol, when he was 3 sheets to the wind, it got in the newspapers and he became an embarrassment and he finally had to retire. Well, McGuire had adjudicated one of Peter's cases in a fashion that did not suit us. So Missouri has this really clever little statute, 527.090. You'll read about it in the Bill of Rights Restoration Act if you should be wise enough to get a copy before you leave. And what that statute does is it allows you to sue a judge and get a jury trial. Now, how we're going to do that, I'm going to show you here just in a minute, because the problem that you have with judges, you can't sue them for money damages, but federal and state, you can get what's known as declaratory and injunctive relief. Title 28, United States Code, Section 2201 and 2202. And this thing is devastating any place except the Ninth Circuit, which is the area, doesn't concern any of you here, I don't think, from Montana, Idaho, Nevada, Arizona, and points west, all the way north to the state of Alaska, and all the way west to Hawaii, Guam, and the North Marianas Islands. They've got, Ninth Circuit, they've got some rules of their own. I mean, these people are just, well, I read you about Rudy Brewster. You know, the sad part of that is they've got a whole circuit full of morons like that. But what this does is this allows a court, once you have invoked jurisdiction, now let me warn you, and let me warn you twice and 3 times, you cannot use these two by themselves. You have to wire them in with another statute. You can wire them in with a Title 42, Section 1983. You can wire them in with a Title 28, Section 1331. Anything that allows you jurisdiction in the federal courts, you can add these two. Now what this means is the judge will declare the rights of the parties, and what this means is the judge can order somebody to do something. It's called an injunction. Or to stop doing something. It's also called an injunction.
What for the audio tape?
Okay. Say again?
2201 means?
2201 means declaratory relief. Okay? It means the court can declare the rights of parties. And some states, and nobody ever uses these, some states have declaratory relief statutes that basically tell you that you can litigate something that right now isn't even a problem and may never be. 2202 is an injunction. Now in Missouri, they have this statute, and it's reprinted in this booklet. Peter's got a wad of them over there someplace, or he did have. What this does is, and what we did to this McGuire is we sued him in a Missouri court. It was his own courtroom, by the way. And we asked that under the Missouri rule, that 527.090, what it does is, see, this is called legal and equitable, and I'm probably going to have to wind up repeating myself on this. But when, in the federal courts, whenever you have what's called an issue at law, that's an issue for money damages, you can demand a jury trial, and if you're slick enough, you can possibly even get one. But if it's what's called equitable relief, like declaratory and injunctive relief, mandamus, writs of prohibition, anything like that, where no money changes hands, that's always decided by a judge. But in Missouri, Arkansas, Colorado, and there are some other states, New York is kind of dicey, You can demand a jury trial and have a jury determine an issue of law. Now, the issue of law we wanted a jury to adjudicate in McGuire's case is we wanted to know, number one, we wanted to adjudicate whether he was a drunken idiot or not. And number two, what we wanted to adjudicate was whether having your case adjudicated by a drunken idiot is a denial of due process of law guaranteed under that clause in the 14th Amendment. Well, here's the funny thing. We had two judges named as the respondents in this action. One of them was a former prosecutor by the name of Mountjoy. Now, bear in mind this was done in the Greene County Circuit Court of Springfield, Missouri. It was their court. You know what the first thing these two clowns did? They removed it to federal court. The last thing they wanted was a jury sitting in judgment of two judges, one of whom was an alcoholic and the other of whom I suspect is incompetent. Now, again, you have to wire these two in with an existing statute, and I'm going to show you some of the others. The Title 42 being obvious, the first obvious one. If you want to sue a state judge, you can't get him for money damages, but according to a Supreme Court case called Pulliam versus Allen, it's in the 104th volume of the Supreme Court Reporters, you can get declaratory and injunctive relief. In other words, if you want to adjudicate the fact that the judge who sat in on your case was completely out of his mind and that was a denial of due process, you can do it just like that. Now, it's doable. Just be prepared for the brethren of the judiciary on the federal bench protecting their buddies on the state bench. But on one other cautionary note here, what I want to point out to you is that when you're in a lower court, now a lot of people, they go to court and they think, okay, you know, I've crossed the line of departure here. I've got, you know, what I want to do is I want to adjudicate this case. Wrong. Oh, what you are doing in the lower court is building a record. Because if you build a good enough record, and you see this guy Bauer, that's what he did with this particular thing of his. I mean, he built a record that's going to make this judge look like a complete fool in the appeals court. If you build a good enough record, then you've got one hell of a chance in the appeals court. In the lower courts, they have a process called summary judgment that I'm going to cover under civil procedure. In the federal courts, they have the same thing in all the states, and what it is it allows a judge to supplant the jury and say, oh, there's really nothing here needs to be litigated, and he throws your case out. Today, in the United States, in the federal courts, and we're talking about people who've hired some of the best land sharks that money can buy, 3 out of 4 cases are determined by summary judgment on the judge's whim. That's from the Yale Law Journal from 1990. There's a real good article there on summary judgment. Now, let me also point out that those of you who are really heavy into this, you're going to find the best stuff. I mean, there's stuff that will absolutely blow you away comes out of these law journals. Now, I know a lot of people think that Yale is a really rotten liberal law school. I got news for you. They have got articles in there that I wish I had written, and I'm just a trifle to the right of Attila the Hun. What you'll find is that articles like, they had a real good one in 1975, the defense attorney's role in plea bargains. I mean, if you read this thing, you'll never, ever hire an attorney for a criminal case. They had the one in 1990 I was just describing on summary judgment. They had another really good one you'll find in Son of Erwin Rommel, titled The Embarrassing Second Amendment, showing all the judicial construction. I mean, some of these law professors, when you read what they've written, you can get a whole education out of a single law journal article than if you access the articles with it. Far superior to anything that I could tell you in this short 2-day period. Now, we're going to go. heavy into this, you're going to find the best stuff. I mean, there's stuff that will absolutely blow you away comes out of these law journals. Now, I know a lot of people think that Yale is a really rotten liberal law school. I got news for you. They have got articles in there that I wish I had written, and I'm just a trifle to the right of Attila the Hun. What you'll find is that articles like, they had a real good one in 1975, the defense attorney's role in plea bargains. I mean, if you read this thing, you'll never, ever hire an attorney for a criminal case. They had the one in 1990 I was just describing on summary judgment. They had another really good one you'll find in Son of Erwin Rommel, titled The Embarrassing Second Amendment, showing all the judicial construction. I mean, some of these law professors, when you read what they've written, you can get a whole education out of a single law journal article than if you access the articles with it. Far superior to anything that I could tell you in this short 2-day period. Now, we're going to go to some other little goodies I want to show you here. We're going to go to Title 28, Sections 2671 to 2680. Anybody recognize that? Okay, that's the Federal Tort Claims Act. And what that does is that's where Congress waived the sovereign immunity that the judges gave the United States. And there are certain actions that you can mount in the federal courts to collect money from the federal government for things they did wrong. One of which is if some federal law enforcement officer, we're not talking state police now, we're talking federal, all right? If some federal law enforcement officer uses you for a punching bag, if he sees that you're in prison falsely or anything like that, you use this procedure here. Now this procedure, this is the Federal Tort Claims Act. Yeah, Title United States Code Section 2671 to 2680. Now let me tell you how nifty this is. What you do with this, and there's some time limits on this. Remember statute of limitations? Anytime you have a claim against the federal government and it falls within the parameters established by these statutes right here, here's how you start it. You have a one-page form. Peter's got some up there in Chicago if you really need one. Just call him up. And what this form does is you simply fill out the form and explain, here's what went wrong. Now, of course, they're government bureaucrats. They're not going to do anything they're supposed to. But 180 days after you have filled out the form and they haven't given you the money, you park this sucker in federal court under these statutes. It's that simple. It's not complicated. Now, I want to go to the next thing here. Title 18, United States Code, Section 1961. Now, Title 18 is normally crimes and criminal procedure. In other words, if you get a piece of paper on it, with your name on it that says United States of America versus you, and over to the right it says Title 18, you have a serious problem because most of the time that's an indictment. It means that if you don't lay down and say, okay, I'll take so many years in prison, you're going to go in front of a jury and get even more years in prison. But in this case, anybody recognize this? Okay, Title 18, United States Code, Section 1961, that's sequitur. RICO, bingo. That's exactly what it is. Racketeer influenced corrupt organizations. This is described in some published opinions as the thermonuclear equivalent of a legal device. And what this does is that if someone has committed a felony and you have been the victim, it allows you to sue them under the RICO statutes. Now, this is not the jurisdictional statute. This right here, this is definitions, and you'll find most federal statutes start with the definitions. Become familiar with the definitions before you try to litigate something, because the definition is not what you want it to be, it's what's defined by Congress. For example, you hear all this business about in the Internal Revenue Service statutes that wages and income aren't the same thing. It's not what they said by statute. They might be wrong by dictionary definition, but that's the statute. And if you think you can go around that without going to the pound, I wish you luck. Now, Title 18, United States Code, Section 201. These are what, and these other numbers here, 1341, 1343, 1503, these are federal criminal statutes. They are also known under the definitions, and there's more of them than this, I'm just using this because these are the ones you will be familiar with. These are called predicate acts under RICO. In other words, if you can show there is a pattern of behavior, then you should be able to litigate this thing. And let me warn you, you're not going to litigate it at the district court level, because some federal judge looks at some pro se litigant walking in with something like this, and it's like, whoops, you know, there's no way we're going to let this guy do this. But quite often, you can get away with it in the appeals court, and then they'll send it back down. Section 201, Title 18, United States Code, that's bribing a witness. Section 1341, mail fraud. Section 1343, wire fraud. Section 1503, obstruction of justice. And does this start to sound like the average proceeding in the average court these days? All right? Problem is that this and this only apply to federal courts. Now these, mail fraud and wire fraud, obviously, you know, that happens just about every day of the week. You just have to show a predicate. Now, these are the other statutes. 1962, 1963, 1964. 1964 is the jurisdictional statute. In other words, this has to go under your jurisdiction statute. If you don't have it, obviously you don't have a RICO. All right? Now the government doesn't have to do that because they can initiate a criminal RICO. 1962, it shows you the conspiracies and the object. In other words, this is the trickiest one. You got to study this one closely. And 1963 makes provision for greasing informers. Now, one of the things you can do with a RICO, and this was done in a criminal case. Here's the citation. This was the Philadelphia Traffic Court. In this particular case, in the Third Circuit, what do you need there? Just a touch? Okay. In the Third Circuit in Philadelphia, they held that the Philadelphia Traffic Court could be a RICO enterprise. And they locked up a bunch of judges over it. You'll find it in 611 Fed 2nd 443. Go to page 450. It's a Third Circuit case from 1979. Now, let me warn you on RICO, this is not something you want to attempt the first time out of the box. If you're just seeing what you can do and there's no pressing time limit or anything, start with something simple like a Title 42 or a Title 28, Section 1331, the General Federal Question Statute. Now, here's another cute one, and I love this statute, all right? Title 42, United States Code, Section 2000, paragraph 2 small b's. Now, what this is known as the Religious Freedom Restoration Act. And if somebody is trampling your religious rights, then you can go to federal court and you can have a determination made as to whether this trampling was kosher or not. Now, what the history of this case illustrates judicial construction as nothing else can. Because what happened was, back around 1971, Supreme Court came down with this business that the government had to show what they called a compelling interest to infringe on your religious freedoms. And of course, in 1990, the Supreme Court flip-flopped, as they quite often do, and they decided that you couldn't have your religious freedoms unless it didn't inconvenience any state or federal government in any way. That's the famous peyote case out of Oregon. You had some Indians up there smoking some dope, minding their own business, and they made a federal case out of it. Well, Charles Schumer, gun-grabbing Charlie, out of Brooklyn, New York, enacted this thing. It was in order to return the Supreme Court back to where they were in 1971. And see, a lot of people don't know this, but the Supreme Court is not the final decider of what is constitutional and what is not in this country. Congress is, always has been. Congress can always override wrongly decided decisions. So this thing goes into law, and the history of it is kind of hilarious because what you see is that in the first place, Congress shall make no law regarding the establishment of religion, all right? Congress didn't have the authority to make this. But the funny part is Congress never would have had to, except that the Supreme Court made a law that they never had the authority to either. So what you've got is, in 1971, the Supreme Court does this. In 1990, the Supreme Court does that. In 1993, Congress tries to clean it up. And now in 1997, this statute's going to go back to the Supreme Court So 9 out of the country's worst ambulance chasers can decide if it's constitutional or not. And if I were the Supreme Court, I'd be treading lightly just about now, because as I mentioned before, Lewis Bowden's book, Government by Judiciary, shows you that this entire idea that the Supreme Court can make law, can adjudicate anything other than a single case, or can set a precedent, is based upon a complete fraud. Can anybody here tell me what statute, what state statute was the first statute that the United States Supreme Court struck down as being unconstitutional? Bingo, Dred Scott, okay? Helped create the war between the states. If they'd have just left it alone, we wouldn't have lost 600,000 men and split the country in half. They struck down another state statute in Roe versus Wade. They never had that authority. The only authority any judge has, including those 9 characters, is to declare a statute unconstitutional in a particular case, period. The whole thing is a monstrous fraud. But here's the punchline on this. Now, a lot of you, some of you NRA members, you'll understand that Charles Schumer would like to take all our guns away. Now, he didn't believe in the Second Amendment, but he believes in the First. And the funny part is that my religious beliefs, I'm the last of the Puritans. You might ask, what's that got to do with firearms? It's got everything. Because when the Puritans, before they became extinct, went to church, you had to pay a cash fine if you showed up without a loaded gun. And I don't want my religious freedoms burdened by any federal gun laws. And nobody has ever litigated that in a federal court. Let's go over here to Title 31, United States Code. This is money and finance. And what I'm going to show you here is this is basically the grab bag. This is where if you see something corrupt, it pays off for you. This is the jurisdictional statute 3730, and 3729 gives you some of the details. But you want to go right between these 2 statutes here. They'll tell you all kinds of nifty things, the main one of which is this. And there are 2 qualifications for this. This basically is, you can forget and wait until some other jerk gets out of line. This allows you to stick your nose in something that really is none of your business. If somebody is cheating the federal government, now, the statute specifically exempts Internal Revenue Service squabbles, so don't get excited, okay? But under the False Claims Act, if you find that the Air Force is being sold toilet seats for $900 and hammers for $600, and you are the person who found it, now, 2 qualifiers here. Number 1, the government has to have been cheated, or somebody is cheating the federal government. And number 2, you have to be able to show that you are the one who discovered it. I mean, if it's on the 6 o'clock news, forget it. It's not going to work for you. Now, by invoking jurisdiction under this statute, you have just become clothed with the authority of the Attorney General of the United States. You can do anything Janet Reno can do. And the beauty of this is that if the United States Attorney's Office decides to pick it up after you filed it, you don't have to do anything else, and you'll get up to 10% of the money they recover. But if they don't pick it up and you have to do all the work, if you find someone that's cheating the government, and trust me, there are plenty of them out there. You probably, walk down a block or 2 and find somebody who's ripping the government off or something. And if you have to do it yourself, if the United States Attorney declines prosecution, then they have to pay you a minimum of 25% of what the government recovers and up to 30%. There are people who make their living doing this. In fact, they had a TV program not too long ago showing a couple of people who were doing just this. These guys are out in their $1 million swimming pools and yachts and big houses and things like that. And that's how this works. Now, there's a caveat here. Under Federal Rule of Civil Procedure 4, that you have to file this under seal. In other words, you don't go down there and just file it and the newspapers come in. What has to happen is once it's been filed, then a federal judge looks at it and he sits on it for up to 60 days before he decides whether to turn it over to the U.S. Attorney or to let you file it in open court. Now, We're going to get into the Federal Rules of Civil Procedure, but before we do, I have a little story I want to tell you. And in the meantime, those of you who want to ask questions, how much time we got, Peter? Got 10 minutes? Start lining up here, okay? In fact, I'll tell you what let's do. Let's just handle the questions, and then at the next hour, I will get to Rules of Civil Procedure, and then we'll just, at the end of each hour, we'll try to get some more of the questions out. Go.
Can you serve your summons by certified or registered mail?
Yes, you can, but you don't do that if you can avoid it. And let me tell you why. Because when you serve the summons by certified registered mail, you also have to put in there a stamped self-addressed return envelope. And if the other side doesn't decide to sign it and send it back to you, you haven't served squat, okay? The last thing you want to do is depend on the person you're suing to cooperate with you, okay? Don't even think about it. I've seen some awful good cases go down the toilet because people tried stuff like that.
Okay, can you serve them twice?
In
In other words, if you send them through the mail,
oh,
now
in
can
fact,
I serve them
yeah, that's a
personally?
good question. In fact, actually what happens is if they don't cooperate in you serving them, then when you hit them with a process server, then they have to pay for the process server. I can tell you right now, for 30 bucks, it's not worth the effort. Pay the process server, get it done right. Don't even think about trying to save money in that area.
Okay, where do you find a professional server then?
You look under attorney services or process servers in the yellow pages. You got them all over the place.
Private investigators.
Yeah, well, my experience with private investigators in that respect has been pretty bad. But a lot of times you can call the courthouse, and the courthouse will either tell you that the sheriff's department furnishes process servers. In other words, in some states like Kansas, all process is served by sheriff's deputies. And those are the best kind to have, especially if you get the guy served at work, because here comes in a sheriff's deputy with his shiny badge and his big gun, and he walks up to somebody and says, "You've been served," and everybody in the place is looking like, "Oh, geez, are you going to jail or what? Get away from me, I might get cooties." Okay?
The sheriff was on this one, so I didn't go through the sheriff department.
Well, no, you can go through someone else. No, actually, if you've got a sheriff on it, and the sheriff's department normally serves the process, you can get another deputy to serve it. But I'm telling you, never, ever try to stint on service of process. I mean, you can do your own legal work, you can do your own research, but the two things you will absolutely never, ever do is file in forma pauperis or screw up or do it half-assed on service of process, because you're absolutely asking for trouble if you do. Do it right the first time, okay? Let me get next fellow.
Well, Michael, my question is a little different than my problem, but I think everybody here from South Carolina will appreciate it. We're having an awful time winning traffic cases. And here's where I came about a couple of months ago in a traffic case. This was a careless operation, in effect a speeding case. You go to court, the judge has got, or they've got to explain the nature of the action.
Yeah.
So they always say it's criminal. Okay, I go with the South Carolina Rules of Court. Okay, the action itself or the ticket is a summons. Of course, a summons is a civil thing. They again say it's criminal. The South Carolina Rules of Court gives no criminal jurisdiction to a magistrate. Everything in there about the magistrate's got a whole section on magistrates. It's all civil.
I see what the problem is here, all right? And let me save you a lot of effort. Whenever you have something where your version of the law is different from the judge's, and you don't want to go through all this crap of having to appeal it and everything else, you go to see if your state has any declaratory relief statutes. And if they do, then what you do is you sue the judge that you went in front of, and you ask another judge to declare what the law is supposed to be in South Carolina relevant to that subject.
I've already appealed it twice, and I get all kinds of runarounds. But
that's not what I said, okay? What I said was you use the declaratory relief statutes. Now, I don't know if South Carolina has any. 37 out of the 50 states do. We're not even talking about federal court. Rather than going to the appellate court, now remember, those guys sitting up on the appellate court, if they're screwing up, who do you appeal to? You don't. What you do is you ask a judge to adjudicate between you and the individuals on whatever court they're sitting on. And if their version of the law is wrong, then you have it adjudicated by another judge. You get a statement of facts and conclusions of law out of somebody, which I'll cover under civil procedure, okay? Ma'am, you're next. And try to keep this brief, people.
My question is, if a...
Can you speak? You're going to have to get up there.
Surely.
Yeah, hang on.
Thank you. My question is, if a note that is a negotiable instrument is lost or stolen, and the mortgage company cannot prove the terms of that note or cannot provide the mortgagor's bona fide original signature on that note, and there was never a confession of confession.
Wait a minute. Let me ask you a question here.
Yeah.
Do they have a copy of the note?
They have a copy.
Okay, let me warn you. In every state in the union, that if an original is not available, the courts will accept a copy. So you're stuck with it.
Okay.
Okay.
Can I ask you
Sure.
what's the source on that? Because
Your
I've
state
read.
statutes. What you have to do is look under documents. What state are you from, ma'am?
I'm from Virginia.
Okay, what you do is you go to the Virginia statutes and you look up documents, and a lot of times you will find documents in your Virginia rules of civil procedure under what they call the rules of evidence. All right? And under the rules of evidence, they will always cover documents, and as soon as you've read that, you will know more about what is acceptable as a document in court in the state of Virginia than I do right now. Okay?
May I say that I have done some research and that the deed of trust may be a copy.
Not what I'm asking you, ma'am. What I'm asking you is, have you read the Virginia rules of evidence? Yes or no?
No.
Okay, you have to do that first.
Okay, may I just say one thing though? That what I've read in terms of case law in Virginia, if there's no original note, not deed of trust, there's a difference there. They can have a deed of trust that's a copy, but the note cannot be a copy. Who is it who, the person, the commissioner of accounts, demands an original copy, original
Okay,
note.
well, if you read the published opinions, then what I would suggest you do is you go to the latest published opinion, you go to the courthouse, you give them the docket number, it'll be right there in the published opinion, and you tell them, I want to buy a copy of the master docket sheet in this case. You read down the master docket sheet, you see where it says what you're telling me, and then you ask for a copy of the judge's order, and then you've got something to go with. But right now, you don't have anything.
Okay, thank you.
Harvey?
Mike, where does a Bivens action fit in?
Okay, a Bivens action, what happened was there's a fellow up in New York City, his name was Bivens, and a bunch of DEA agents kicked his door in and rousted him, and he sued in the federal district court, the Second Circuit Court of Appeals, and they all just blew him off. He got it up to the Supreme Court, and the Supreme Court said, well, this is obvious. This was a Fourth Amendment violation, and the statute that you use is Title 28, Section 1331. Remember the federal analog of Title 42, Section 1983? But that's all there is to it.
Okay, now, is a mandamus also covered under USC?
Absolutely.
Writ of mandamus.
Under Title 28, Section 1361, or if it's a judge, 1651, All Writs Act, okay? Yes, sir.
Correct me if I'm wrong, but as a matter of jurisdiction, one can be a U.S. citizen or a state citizen / American national. Can only a U.S. citizen file Title 42 suits?
Okay, well, you really want me to correct you?
Yeah.
Okay, because I'm going to. All right. The only time that you could be a state citizen and not be a citizen of the United States, and I ought to know this because my ancestors fought for the Confederacy, was between 1861 and 1865. The Union ratified the 14th Amendment in 1868, and what you will find if you read the first sentence of the 14th Amendment is that everyone who is born or naturalized in the United States is a citizen of the United States and a citizen of the state in which he resides. All right? That was a good argument prior to 1865, but the fact is we lost. Okay? It won't hold water now. In fact, actually, you can be a foreign national. You can be a citizen of United Arab Emirates, and you can come over here and you can still file Title 42, because the minute that you cross into the borders of the United States or its possessions where they have federal courts, United States federal law applies whether you are a citizen or not. Okay? All right. Any other questions? Boy, this is the biggest audience and the fewest questions I've ever seen. All right, now, what I'm going to do is we're going to have a couple minutes before the break here, and then I'm going to get you into the Federal Rules of Civil Procedure. Now, again, the Rules of Civil Procedure, we're dealing with the Rules of Engagement. And what we've got here is a situation. Remember facts, law, and procedure? Now, what they kill you on is procedure, and here's why. Because the facts are like a chessboard. You have 64 squares, and they're light-colored and dark-colored, all right? You have pieces on the chessboard. Those are the equivalent of the statutes, some of which I've given you here. But where you get killed on a chessboard is the guy sitting across from you, you don't know which statute he's going to use. And it really doesn't make any difference because he's going to use them all anyway. But it's the procedure. And the procedure in any court, federal or state, is the equivalent of how you move those chess pieces. And the one thing they will absolutely kill you on in any federal or state court, if you're up against somebody who's had experience, is the procedure. And if you don't learn the procedure, I mean, what I've given you here is just the jurisdiction, okay? The legal claims are so varied and they're like the colors of the rainbow. You'll find most of the time that the legal claims will come under the statute that you're invoking as jurisdiction. For example, Title 42, Section 1983. If you want to know what kind of actions are available, you go to the law library, you pull the volume, you flip it open, and you go down the index or the header notes, and it'll tell you all kinds of different things you can do. Police, prisons, municipalities. I mean, it'll give you a real good idea how this stuff works. So there's no point in covering it here because I would be covering it for 3 people and the rest of you wouldn't apply to you. So before we get into procedure, Peter's holding up all my 30-second, things and shut my water off. Anyway, what we're going to do is we're going to take a 10-minute break, and when we come back, I'm going to get you into procedure, but I'm going to tell you a story before I go to show you how procedure works, just like I told you about don't strike your colors. If you're going into federal court, or if you're going into state court, and you're going to start a court fight, don't even think about backing up. 10 minutes, everybody back on deck.
And please do stay close. We're really going to try for 10. We would like to do 8 sets today, which will take us. I know that.
All right, now what we're going to do is you understand jurisdiction, you understand facts, you understand summons forms, you understand relief requested. It's all there in your course material. And now what we're going to do is we're going to separate the men from the mice. Because what we're going to cover now is your rules of engagement, which is what I showed you to begin with. All states in the Union have similar rules, and some of them track the federal rules almost exactly. This is how you move the chess pieces. You are not a chess master if you know how to move a pawn and get clobbered. On the other hand, you're going to find that almost every single time, like I told you in the beginning, that you run into a problem, your problem is going to be the other side is using an avalanche of procedural gimmicks to derail you. Now, before I get into this, I want to tell you a little story. I had a next door neighbor, this is going back about 27 years ago. This fellow's name is Bill Nauta. He's still around. Now, this guy may be one of the greatest hand-to-hand combat trainers on the face of the planet. He's done everything. He would have been a world champion judo player, except that he pulled a ligament in his knee or something and he kind of had to hobble around. Had a lot of problems. By the time he was 16 years old, he had 160 professional fights. He lost one of them on a decision. He went home because his manager was kind of a dissolute sort. He was disillusioned. He was a young, idealistic kid at the time. And when I met him, it was in 1970, and he was training a kid named Jerry Johnson. Now, Jerry Johnson had never had a fight in his life in the ring. I don't even know if he'd had any on the street. I suspect he did. And Jerry Johnson's first fight, he was up against a kid named Randy Shields. Now, Johnson had him by about 10 pounds, as most of you will have most lawyers by about 10 IQ points. But he'd never been in the ring before. And Randy Shields' father was a professional light heavyweight, and Randy Shields had had over 100 fights. Now, any of you who know anything at all about boxing know you don't put a guy in the ring the first time against someone who's had even 30 fights, let alone over 100. But Bill Nauta did it. And I was curious as to how Jerry Johnson was supposed to survive. And here's what Bill Nauta told Jerry Johnson. He said, look, he said, here's what's going to happen. He said, this kid's had over 100 fights. Here's what he's going to do. He's going to dance away from you. You're going to follow him. That's what he's depending on. He's going to suck you into the ropes. He's going to come off those ropes with all that spring from the ropes, and he's going to hurt you. So Jerry says, what do I do? Bill says, it's real simple. Here's what I want you to do. I want you to go to the center of the ring. I want you to keep your gloves up and your elbows in. Can't hurt you. I mean, you know, hitting something on the top of the head really doesn't do him much damage with a boxing glove. He said, and when the kid dances away, do not follow. So Jerry says, okay, I mean, it's the only way he's going to survive. So he goes in the middle of the ring and he's standing there just like this, and the kid dances away from him. And Jerry just stands there, you know. And so here you've got this kid with over 100 fights. He keeps trying the same stunt. And Jerry is not falling into the trap. So finally, about, just a few seconds into the third round, I mean, this kid's completely flustered. He's had over 100 fights, and here's this other kid just standing there, just like this, and every time he dances away, you know, he doesn't follow him. You know, he makes him come back, and this kid's completely confused. So a few seconds into the third round, this kid makes the mistake of getting in too close, and they start going leather for leather. And Jerry, because of his 10-pound weight advantage, he's hurting this kid. And by this time, the crowd's on its feet. I'm one of them. You know, I'm screaming, Jerry, take him down! All right? Well, Jerry Johnson, because he'd never been in the ring in his life, he thinks all the screaming is because he's in trouble. Okay? So he jumps back. Well, by this time, this kid realizes, I mean, he'd got taken a couple of real good body shots. And this kid realizes he's going to get hurt. So the fight ends in a draw, all right? Nobody wins, nobody loses, it's a tie. That's not the punchline. Punchline is this. Now remember, when you people go to court and you stand up in court, don't try to get fancy. They'll dance away from you. Don't allow them to do it. You just stand there with your gloves up and your elbows in, because here's the punchline. 10 years later, I'm reading a copy of the Ring magazine. And I turn to the rankings. And as a middleweight, guess who is ranked number 5 in the world? Randy Shields. All right? In other words, Jerry Johnson, simply by that one tactic, had not only survived, but almost won a fight with a kid who was destined to become a contender. Now, when you reach the top 10 in boxing in any given weight division, you are in the top. You are what's called a contender. You may not be the world champion, but you're up there. Now, every one of you here can do exactly the same thing. Do not try to dance away from these people. Do not let them dance away from you. Do not get fancy. You just go into that courtroom and don't try to get cute. Do not try to match them. Do not allow them to suck you into the ropes, because they will if they get the chance. Now, what we're going to do is, when I've given you that example, there's another example I'm going to give you. It's called Vista Irrigation District. Brown and Miller versus Vista Irrigation District. My landlord and I sued not a municipality, but a state agency in federal court about 10 years ago out in San Marcos, California. They tried to shut our water off. I'm going to get to that in a minute. Now, let me run you through this by the numbers. In fact, before I do that, I want to read you a little something here. This is Rule 1, Federal Rules of Civil Procedure, and these rules shall be construed and administered to secure the just, speedy, and inexpensive determination of every action. If you believe this one, if you believe that any judge or lawyer is going to construe these rules in that fashion, there's no hope for you. Now, I'm going to take this by the numbers. In the Federal Rules of Civil Procedure, there are approximately 84 of them, but they have little sub-rules like, paragraphs A, B, and D. And I'm going to give you the basics here. Now, in order to really get down to the fine print, obviously, you're going to have to buy the Federal Rule of Civil Procedure book or the State Rule of Civil Procedure book. And the reason I'm not covering criminal is because we really don't have more than 1 or 2 people here that even have a criminal problem. 90 million lawsuits are filed in the United States every year. Those are all civil actions. We only lock up 1.5 million of our citizens every year. So the odds are 45 to 1 that your problem is going to be civil. Federal Rule of Civil Procedure 4. This concerns service of process. Again, and I cannot stress this often enough, do not even think about getting anyone other than an experienced professional process server to tag the other side with this. You send a friend or relative out to do it, but trust me, there will be some procedural gimmick, some slick lawyer will figure out how to derail you on. Now, rule number 5. Rule number 5, it covers what we can call certificate of service. And let me back up here just for a second on rule number 4, question during the break, which was a legitimate one. It was serious enough. Don't add every human on this thing if you're going to have to pay $30. You don't need 30 defendants at $30 a piece. It's going to cost you $900, and the court's going to throw off 27 of them anyway. Keep it specific. Rule number 5, once you have tagged someone, once the process server has hit the other side with your lawsuit and the summons is on file at the court, now you actually have an engagement. But all future paperwork that flows back and forth comes under Rule 5, Certificate of Service. Now you'll find it in your course materials. It will show you how to fill out a certificate of service for every document that you fire at the other side. Don't even think about sending something to anybody in this litigation without a certificate of service, because if you file a document in court without a certificate of service, you have filed nothing. And let me also caution you on certificate of service. What will happen a lot of times, this is a trick that attorneys will use on pro se litigants all the time. U.S. attorneys used to use it on me about the 3rd time I figured out what they were doing. And what you do is that when you see stuff going back and forth, never, ever trust a member of the bar that you are up against to do the right thing and send a certificate of service. Because quite often, I see a lady shaking her head here like, yeah, she's been down this road before. What will happen quite often is that the attorney from the other side will file a document in a case with a certificate of service that he mailed it to you, and he's lying like a rug. So every Friday or every Monday or every couple of weeks, you know, whatever you think it takes, you call the court clerk and you ask her to pull the master docket sheet and you see what's been filed. And if she says, well, on 3/11/97, there was a motion to dismiss for failure to state a claim, and it is now 3/20/97, it's been 9 days, and it's only supposed to take a couple days in the mail, then you know you've been had, and what you're going to have to do is go down to the courthouse, pull a file, get a copy of it, and respond accordingly. I mean, I've had cases where you can go in every Friday, and the attorney from the other side, I mean, a lot of these attorneys are really slow. We had one out in California. I think this guy pulled this stunt about half a dozen times, and he could never figure out why we kept showing up in court, even though he knew he hadn't mailed the stuff to us. Well, we were just checking it every Friday. Every Friday, I'd go down to the Vista Courthouse in San Marcos, California, and I'd say, here's the file, Brown and Miller versus Vista Irrigation. Let me see the file. And I'd say, oh, okay, this is what they filed. So I would get a copy of it, cost me 50 cents a page, take it home, write up a response, and fire it in. And every time we went to court, this attorney's looking at us like, who are you people? You know, how come this isn't working? The next thing we have, this is Rule 7. Rule 7 describes the difference between pleadings and motions. Now, there is a difference. Rule 7 will describe what is a pleading in Section A, and anything that is not a pleading in Section A falls under Section B. Now, you may think, what do you care what the difference between a pleading and a motion is? Well, you're going to find out here in just a minute. There's a world of difference. Because under Rule 8, if you go by paragraph A, they're going to tell you that they want a short and plain statement of your problem. In other words, like I said earlier, if you turn in 300 single-spaced pages, your case is going to go back out of that court, federal or state, in a heartbeat. Nobody wants to deal with it. It's got to be short and plain, but it doesn't have to be that short and that plain. In other words, we're not talking about something that's 1, 2, or 3 paragraphs. What we are talking about, if you can't get it together in 10 pages, typed double space or less, then you're probably getting a little too verbose. In other words, what they're going to do is they're going to ask that your complaint be thrown out because you had diarrhea of the typewriter. And if all the facts in there actually have to do with the situation to where it takes a full explanation, the odds are you're going to survive that. Now, here is the difference. This right here is deadly, but before you can make it work for you, you have got to be able to tell the difference between a motion and a pleading. Now, a pleading is something like a complaint, an answer to a counterclaim, things like that. It'll be all defined for you right here in the book. What makes this so deadly is that failure to deny a pleading is considered an admission. It's sort of a junior default. Next we're going to go to fraud, which is Rule of Civil Procedure 9. We're going to go to numbered paragraphs 10. We're going to go to sanctions 11. And we're going to go to failure to state a claim 12. Now, 9B, and attorneys will do this to you all the time, if you quote what he did and it's fraud, they'll say, oh, well, you didn't state it with particularity. Well, the problem is that particularity only means that the other side has got to be able to see what's going on, and you have to read that in what's called peri materia with Rule 8. In other words, Rule 8 will tell you short and plain statement. So you don't have to go on and on and on when you've been the victim of a fraud. You have to read those two together. You'll find the published opinions will tell you that. And it's something that attorneys, anytime that you plead fraud, they'll start squealing, oh, you didn't plead it with particularity, but they won't tell you what the problem is. The remedy for you not being clear enough is not a dismissal or anything like that. It's called a motion for more definite statement that they never use. Now, Rule 10, especially paragraph B, what it tells you is that when you file a complaint in a federal court, they want you to number the paragraphs. They don't want to have to try to figure out where things are. In other words, if you tell a judge that something's on such and such a page, you had better be able to tell him what paragraph he needs to look at the same time. It's not that difficult. number the paragraphs. Number 11, these consider what are called sanctions. When an attorney signs something or you sign something, it had better not be frivolous. Because if it is, if it's not warranted by existing law or there aren't facts sufficient to justify saying that the existing law is basically horsepucky, then you've left yourself open for sanctions. Let me give you a case in point. In the case that I was telling you about earlier, in which we lit up a couple of state judges in Missouri, the other side, the Attorney General of the state of Missouri, has tried unsuccessfully 3 times to keep this thing in federal court. First, they filed a removal action out of their own court. We did a motion for remand, which was granted by the federal judge. He said, this thing involves a child custody issue. It has no business in federal court. He quoted the 8th Circuit case law, and he tried to send it back. 3 more times, the Attorney General of the state of Missouri has tried to lock this thing into federal court, and he keeps raising the same issue. Now, he's left himself open for sanctions because what he's doing is not warranted by existing law. He's already been told once. And under Rule 11, what you have to do under the new rules is before you put in a motion for sanctions, you have to write the other side and be sure you do it with a certificate of service, certified return receipt requested, even a process server for this one probably wouldn't hurt. And you have to give them 20 days or 30 days, I forget right off the top of my head, to withdraw the nonsense. And if they don't, then what you do is you go in and ask for sanctions. And what surprised me was, when I got to looking at this rule and started looking at the case law, the sanctions delivered against someone for not withdrawing something from federal court, this one particular judge said he didn't see where he could award anything less than $2,500. Exact same situation. Now, Rule 12B. Okay, now remember what I told you about more definite statement, that's Rule 12E. But 12B, this is where they get every pro se litigant saying, what did I do wrong? And what this is this is saying that you have filed something in which you have failed to state a claim. Well, that would be true if you sued somebody in federal court saying, you know, your dog is ugly and that's causing me emotional distress. You have failed to state a claim upon which relief can be granted. On the other hand, what you're going to find, most of the time you get this 12B language, it's boilerplate. In other words, they really don't have any other defense, but yeah, I see a lady shaking her head down there. She's been down this road before, okay. What it does is it simply takes the average pro se litigant, he looks at it and says, oh geez, what did I do wrong? Not knowing that he's being the victim of the usual court fraud. Now, let's go back to Vista Irrigation for a second. They did this to me 10 years ago, all right? And I got to tell you that I had been in this business suing people and being sued, oh, it had to be like, let's see, 87, about 13 or 14 years at the time. And I got this piece of work, in other words, George Miller and I, because we didn't want our water shut off on his 4 acres that I was living on, George Miller and I sued the Vista Irrigation District. We were the plaintiffs. And about 20 days later, here comes the response. And I read this response and my heart sank. I thought, oh man, you know, am I this wrong? So I put it down, I think, you know, Brown, you're too old for this, okay? So I went back and I picked it up again and I sat down and I read it a little more carefully the second time. I thought, you know, there's a couple of holes here. So then I put it down again and I sat it down again and picked it up again. By about the 3rd or 4th time I'd read this thing, I thought, oh, okay, I see what this girl's trying to pull on me. And I realized it was the usual failure to state a claim that was one of the cleverest pieces of work I had ever seen. I mean, she had me convinced, and I'd had over 10 years experience. And the funny part of this is, this girl calls me about, oh, it's less than a month later, and she'd signed her name to the pleadings and all that. And we had to have some phone conversation about discovery or something. And I told her, I said, lady, I said, I got to tell you, I said, that was the slickest piece of work I have ever seen in a federal civil action. I said, you like to had me convinced. And I said, I've been doing stuff like this for over 10 years. And she started laughing. And she said, well, Brown, she said, you want to know the rest of the story? I said, yeah, if there's I said, you've got to be the best attorney I've ever been up against. And she started laughing. And she says, Brown, you want to hear the rest of the story? I said, yeah. She said, when we got hit with that piece of work of yours and Miller's, she said it took an entire law firm, all 6 of us, 3 weeks to put an answer together. Okay? You know, the irrigation district that we were suing, they could have given us free water for the rest of the millennium and they'd have saved money. Oh, the other thing that they're going to do too, I got to caution you on, that when you get into your failure to state a claim, they'll come back with plenty of case law. And you look at all these decisions and that, and you'll think, oh, how intimidating, how could I be so wrong? Well, you're going to find about 70 to 80% of the time, the stuff they're hitting you with, if you go read it, it doesn't say what they say that it says. In other words, it's a form of serious fudging that nobody ever gets that excited over. And a lot of times what you'll do is, if you're smart, is you will go read the cases that they cite, and you'll quite often find things in their own cases to use against them, and you can use those cases as a starting point to shepherdize, which you'll find in your course materials. Shepherdizing is simply a way of taking a case from, say, 1979 and seeing how many times that case has been quoted up until very recently and see if there have been any new principles developed in the law or any new judicial construction or whatever. And so always read what they send you in their motion to dismiss, because like I say, when you get it, it'll be boilerplate, it'll have misquoted case law if you've done your homework right, and spend some time with it. I mean, you know, you can learn a lot from these people, and the beauty of this is the legal system is the only system. You will not find this in any other type of competition. You won't find it in boxing. You won't find it in the academic world. The legal system is the only place where the other side will teach you what you're doing wrong. In other words, if you've done something wrong, they will gleefully point it out. It's just like I tell people, I can get into a case and I can learn 80% of everything there is to know within 3 weeks or less. If I try to learn 100%, it'll take me a year and a half. But if I do it in 3 weeks and fire it at the other side, they'll come back with enough stuff to teach me the 20% I don't know. In other words, they're actually going to do you a favor. Okay? Now, let's go to some of the other rules here that we've got, because what I'm going to do here, like I said, is take you through them by the numbers, and when I get through with these rules, what we're going to do is we're going to have questions. And if you don't ask me questions, I'm going to ask you. I'm going to see who's been asleep and who hasn't, because this is not Dale Carnegie's How to Win Friends and Influence People. This is combat law, this is basic training, and you will learn or else. Now, let's go to some of the other rules we've got here. Let's go with rules 13, 15, 16, 18 to 21. And what you're going to see here is I'm basically just gluing some of these things together because you're really not ready for them now, and a lot of times they won't even concern you. You're going to find that the Federal Rules of Civil Procedure, in any contest you get into, maybe 1/4 of them or less will even concern you in any way, shape, or form. Rule 13 is what's called a counterclaim or cross-claim. In other words, if somebody sues you and you want to sue him back, you file what's known as a counterclaim. And the way you do that is you simply take the complaint, and if you get to it quick enough, you just take the caption, you do another caption of your own right underneath that caption. In other words, remember the little parentheses, right-hand side parentheses, and the line underneath it? Well, you just add one of those, only this time you are the counterclaimant and they are the counter-defendant. You just plug it in and send it back, and since they've already paid for service of process to sue you, they've saved you the 30 bucks. You just put a certificate of service with it and back it goes. A cross-claim is when 2 or more of you are being sued, like let's say this gentleman here and I are being sued. And I'm saying, wait a minute here, okay? It's his fault. So what I do is, same drill, only I name him, because he's originally on my side, as a cross-defendant. In other words, we're being sued, plaintiff, defendant, cross-claimant, and then I name him again. Okay, I name him as a cross-defendant. All right?
Page 15, tell us.
What's on page 15? I haven't read that thing. Okay. Page 15 in your course materials, but things have changed a little bit. So I wrote that book 17 years ago. The information is still accurate as far as the basics go, but don't ever take anything in there as being up to the minute, because it's not. You're going to, the fact is, they change these doggone rules every year or two. They just changed Rule 11 on us here a year ago. They changed Rule 26 2 years ago. These things are in a state of flux, so you always want to go with the latest book on the rules of engagement. Now, Rule 15, these are called amended and supplemental claims, all right? What you can do is, under Rule 15, you can, and let me tell you the difference here. When you amend a complaint, it's when you bring up something that you should have done in the first place, but you didn't because you didn't have discovery or something else. When you supplement a complaint, what you're doing is you're adding things that have happened since the original complaint was filed. And what you do here is on this particular process, anytime within the first 20 days or before the other side responds, you can just amend it as a matter of course. It's a real good way to ambush somebody if you feel like it. But after that, once the other side has responded, you have to have a court order, and most of the time they're supposed to give it to you. Rule 16, these are called pretrial conferences. In other words, what they're trying to do is, once again, they're trying to keep you from in front of a jury. They're trying to set a date for a trial. They're trying to see if they can make a settlement. They're setting limits for discovery. There are all sorts of things like that that you do at a pretrial conference. And when you get one of these things that say you have to be in court such and such a time for what they call a scheduling order, don't be intimidated by it, because if you can just sit there and keep your mouth shut, you'll find most of the time they'll go through the drill, and unless you have a serious objection as to when they're going to cut off discovery or when they're going to have a trial or whatever, just let it go. Most of the time the other side will do the work for you if you're the defendant. If you're the plaintiff, then you better get up on this, because you have to set this. But again, this isn't something we need to spend a lot of time on right here, because this is something you're going to run into down the road. You've got to do your complaint, you've got to get your answer, you've got to get your motion to dismiss, you've got to file your objection to motion to dismiss. You've got to go through all this before you get here. Now, Rules 18 to 21, this is similar to amending a complaint, but this is called these are called joinder of claims and remedies. And let me warn you about something here. Two of the doctrines you're going to run into, and they're known by different names, collateral estoppel and res judicata. They are the civil equivalents of the double jeopardy provision of the Fifth Amendment. In other words, if you name the wrong cause of action and you litigate this thing and you lose, and then you realize you made a mistake, that you should have done it another way, you don't get another chance. It's called claim preclusion and issue preclusion. In other words, you had better get it right the first time, which means if you discover something in the middle of this litigation, you'd better use one of these rules, and if you've got another claim or another remedy or whatever you want, and 25 is substitution of parties, all right? 25 simply means that you sued the wrong dude and now you need to substitute somebody. You better get it taken care of ASAP. Don't even think about waiting until the whole thing's over and trying to do it again, because they won't let you. Now, number 23 here. Anybody recognize this? Everybody talks about it. Bingo, class action, okay? Most overrated thing in the history of the American legal system. Everybody talks about it, and I'm going to tell you right now, for the most part, it's an absolute waste of time, because a class has to be certified by a judge. And I'm going to tell you right now that no pro se litigant by himself, or even 5 or 6 of you, is going to get a class action certified by a judge, because when this thing is litigated, whatever the ruling is, it will affect all the members of the class, not just the people who joined the complaint. So don't waste your time with it. Don't waste your time discussing it. The other thing is if you try to be the, save the world and all that kind of stuff, you got no bargaining chips. In other words, the best cases, old attorney in Kentucky.
The store's out of business. Now they've got a monopoly, and they've got the people. They can charge anything. Prices are outrageous. What's a 99 cents at Pathmark is $3 at A&P. They think nothing of letting their prices go into $3. What do I do for Rusty 3 times a day? 1, take him for a ride. He loves to ride. Take him for a walk. Patiently wait for him to leave his calling cards on every post, every tree, every bush, every hedge. Clean up his poo. Rub the loose fur out of his back. Clean out his eyes. Feed him, give him water. And drive him back to his moor at Moore. We moor him at Moore. Bob Moore is an angel to let Rusty stay under the shade of that beautiful tree. About 3 hours a day. You, fireworks for you. But by the time I did, it was over. And just as suddenly as it began, we returned to the deep black of the night and the deep silence of the night. That's the lake. FDR Jr. Used to live. How long ago did he die? About 7 or 8 years ago? FDR Estate, FDR Junior Estate. It was sold to a developer, and now there's a zillion houses up here. Now all of these rail fences. Summer resort here. Century 21. They're all brand new and they're all empty. Thank you for visiting us today. Champlain Drive, Sagamore.
Ralph is not here, is he? Ralph has been struggling with cancer. We would appreciate you continuing to lift him up in prayer. The surgery did go well. He will have some radiation and some chemotherapy. The rest of the congregation, take a look around you and give these folks a hand. I invite that hand to be extended not just this morning, but also through prayers this week, because they will certainly have a fun week. But it will also be a challenging week at times, and especially with the configuration of our physical plant this year. There'll be some challenges that we don't even know about yet. So just pray that God guides them through those fun and exciting challenges this week. And yes, you got a prayer request?
Pax Vobiscum, I ask the congregation to pray for William and Celeste Budrow, that the terrible burden upon them be lifted immediately.
William and Celeste, we will lift them up in prayer. I shared with you that this week we had 4 people that I guarantee you, because I've been to Christ Care training, these people did not...
Wherever you go, people gather, worship God. I like that. At 84, you take 84 east to 684 and take 684 to 35 and cross river. Time is 11:11, the magic minute. Thank you, God, for church. Thank you, God, for inspiration. Thank you, God, to walk it. Thank you, God, action. Thank you, God, faith. Rusty's very happy. He just loves to ride, stretched out in the back seat of his luxury car. Through this mountain. .30 a.m., 5 miles west of Brewster. 684. I think that's so interesting. Town. Looks dead. The time is 12:40 p. The mileage is 51. At 1:15. Two people wouldn't sign and one person did. All the money Charles Dolan takes in from Yorktown. Look at this. Don't mind me, lady. I'm just trying to get by. Well, okay.
finally decided to move.
Government. The effect, and I've seen it now in my 12th year in the town.
Michael O'Connor?
Yes, Michael G.
He's running for council again this year. Michael, what do you hope to accomplish?
Well, I'd like to, Glendora, it's a pleasure, first of all, to meet you. I'm sorry that it's the, an overcast day here in Ossining, but as we Irish like to say, this is a soft rain. And of course, we need a soft rain here. But more than that is we need a real hard cooperation between the village of Ossining and the town of Ossining, the village of Ossining, the village of Briarcliff, the village of Croton, the town of Ossining, village of Briarcliff Manor. Every small and medium-sized community that we have that's the outgrowth of a single community or a group of communities must be working together.
Work together.
We have to have cooperation. Through economy of scale, we can bring down the cost of local government. The effect, and I've seen it now in my 12th year on the town board, one of the things that came up 12 years ago was buying a special truck. Now, this truck is expensive, and what it does is it cleans out the sewers and it cleans out the catch basins that collect in the rain and they fill up. Now, if these are not maintained, and they will cause damage to the infrastructure underneath of our streets and roads. They must be cleaned and maintained periodically all year long, so that when heavy storms are up, we rent this equipment. For what the town has paid over the last 12 years, we could have purchased our own truck.
Yeah, right. And now cooperate.
We tried to, in the past, get a machine that could do this type of work. And I'm using this as an example for all of the problems that we have in our community, no matter what it could be. But if we cooperate, we can purchase one of these machines, share the cost, spread it out, and we all use this equipment. Now, it's not a piece of equipment that's used every day. Therefore, its lifespan will be very long, and the minimal impact, financial impact, the impact of your dollars, your tax dollars on your home is minimized by this. I hope to do what we've done in the past. When I first came on the board, we didn't have the kind of cooperation that we saw later on. Underneath the leadership of the boards that I did serve on, we were able to have a consolidation of services between the village of Ossining and the town of Ossining in the financial areas, collecting of bills, our recreation, and we did save money in these areas. my goal as I go in, I'm running now for my 4th term on the town board, is to see to it that this type of cooperation will continue and that the hand of friendship will be reached out. And let's get rid of any problems or any personality conflicts that sometimes exist between elected officials, and let's work towards the good of our entire community, every taxpayer here. So as we look at the soft rain today here on this Sunday afternoon, let's hope that we have a soft future and that we can work together to try to bring down the cost of local government.
Oh, good.
And let's get away from those unfunded mandates from the state, and we'll really be doing well.
Way to go, Michael. And Cablevision better be good to you, because you can take away their franchise, right?
Yeah, you and 10 attorneys will differ on that one, I'm afraid.
Thank you.
Thank you very much.
5 is 61. The hour is 1:33. p.m. That was wonderful. He knows Charles Bryant. He looks like him. Our next stop is Harrison and Portchester, and I guess it's best to go down Route 9 to 287, or you go back to 9A. Want to go back to 9A? Yeah, that's right, that would be in the right direction. Tell you what, we'll take 133 back, because that goes south and 134 goes north. So 133 should come to 9A or something like that. Nine A. What'd they do? Miss it, huh? Okay. 9A south. Hey, that was pretty good, except I missed it. It's so hard to see. Okay, 9A south, 287 to Portchester. And that'll be number 4. We've got 3 out of 6. Junction, Route 100. Miss America. Yeah. Straight ahead is 287. We'll take it east to Portchester for number 4. Going toward the Tappan Zee Bridge. Oh, poor people. I'm so sorry for them. Now, that's an accident, construction, or volume. Number 10 envelopes and staples and a razor blades. It's now 2:41 p.m. The mileage is 82. And let's go to New Rochelle. exit, Harrison and Rye Playland. I might as well drop off the New Rochelle tape and the Harrison tape at Cablevision Harrison. Billion Vernon. In stock. I wish they would do something about the way Cablevision is operated and get it away from the domes. Oh folks, Con Edison is up the road. Headquarters for Con Edison. My, the fights I've had with them, but not lately. 47 Purdy Street. Back to 295. Oh, I just gotta look at it. It's moving anyway. Recognize this road? This is Executive Boulevard, Yonkers, going up to Cablevision. I'll check all these forms and I'll hand them all in. There's the water tower. And the mileage is 110 miles. We're from Bethpage, and he got the envelope for Brenda, and he'll put it on Brenda's desk. Okay, now let's leave for Ossining. Folks, I was in the dollar store yesterday in New Rochelle, and I just could not resist this pail. I bought Franklin 12 to 13 hand towels. Look at this pail. Isn't it great? I have no use for it, but I just couldn't resist it. Okay. We have a whole lot of things to report to you. The legal papers are up to date. Saturday was the second Saturday I had free, testing the audio, I had free time, and that would go back to like 1997, 3-4 years. So it's good, it's good, it's good. What a great pail. All right, let's turn this over and start from the bottom up. We have here another crooked action by the crooked Second Circuit, the United States Court of Appeals for the Second Circuit. And it says that a stated term of the United States Court of Appeals for the Second Circuit, Second Circus, held at the United States Courthouse, Foley Square in the city of New York on the 25th day of July 2001. Glendora Plaintiff Appellant versus the New York City Parking Violations Bureau. Defendants Appellees on January 14, 1998, this court issued a leave to file sanction against Glendora. They did not. It was never signed by a judge. Anything signed by a clerk is bogus. See Glendora versus Telecommunications Incorporated. Glendora now applies for leave to file an appeal from a district court order which imposed monetary sanctions against her for violating its own leave to the file order. That's not true either. Half the stuff that you read in the record in the federal courts, it's just plain not true. It's a bunch of lies. Glendora versus New York City. Upon due consideration, it is ordered that said application is denied. I don't know what they denied, do you? I have no idea. It's nothing but gobbledygook. It says, for the court, Roseanne B. McKechnie, clerk, by Lucille Carr. Lucille Carr is a nothing. She's a flunky. And Glendora says, who, quote, considered, unquote, it, approve, quote, due consideration, unquote, What are the names? Glendora is entitled to an Article 3 judge, and you don't make a case. So here is a motion to this stupid court, the Second Circuit, U.S. Court of Appeals, and this is a motion for telling Glendora the names of the judges responsible for the July 25th quote-unquote order. It's not really an order, it's a nullity. And there isn't any opposing counsel, and with judges this bad, who needs opposing counsel? And who is the judge's decision? What's the name of the judge whose decision is being questioned? Michael B. McCasey, an idiot. Glendora has a right to know the names of the judges who wrecked this great American fight for right. The New York City Parking Violations Bureau was a case against civil RICO. The cops in the city of New York and the whole bureau go out and rip people off, violate rights, violate the law. They break more laws than any gang of gangsters you can think of. And it was a fight against that, and of course the judges are in on it, and so it meets the same end that they all do: a crooked United States District Court, a crooked United States Court of Appeals, and nobody can beat the Southern District of New York and the Second Circuit for being crooked. Now we have something from that crazy man named Bernard Madsen, another crook, working for another crook named Karen Grieve Milton, and this is a complaint of judicial misconduct against Colleen McMahon, a cheater from the beginning, an apt person who has given up her oath, who has betrayed the United States of America, and they won't even say her name on here because they cover up dirty judges. And Glendora sent a copy of this to the Center for Judicial Accountability and to you, the Glendora TV audience. And Glendora says to Bernard Madsen and to Karen Grieve Milton, why don't you go out and earn an honest living? Why don't you do something that your family can be proud of? Coming up next, do not go to Fleetwood Car Care Incorporated. They are a bunch of thugs. They are located at 48 West Broad Street in Mount Vernon. Do not go there. A bunch of thugs. Marie Cayabas, Fleetwood Car Care Incorporated, and it's an Exxon gas station. Do not go there. Consumer Report.